We are off and running. Hey, Judy, how are you?
Hey, Sean, great to see you.
You too. It's been a while since we've seen each other in person, but hopefully one day soon we'll be able to get back to a coffee shop.
That would be nice.
Yeah. Well, first of all, I want to thank you for doing this. This could be a really interesting conversation because it kind of fits into my day job and to your basically your life, in lack of a better term. So I can't wait to get into the conversations. But before we do that, I want to thank everybody for tuning in. If you're a returning member, thanks very much for your patronage. If you're new to the channel, make sure you hit subscribe with the bell so you get notified when new episodes are posted on Thursday mornings. Also, if you like this video or any of the previous videos, be sure to give us a like because it does help build the channel that way. So for those of you who don't know, my name is Sean O'Rourke and you are watching Did You Know That? ? The channel I started where I get to talk to interesting people about interesting topics. And when I'm not doing that, I'm a cyber liability consultant for an insurance brokerage firm, which means I essentially prepare companies to be hacked. And Judy, that's kind of the reason why you're here. So why don't you tell the fine folks who you are and what you do?
Great. Sean, thanks so much for inviting me to speak with you today. This is really cool. My name is Judy Selby. I'm a partner in the New York office of Insure and Culbertson. I'm a member of the firm's Global Insurance Services Practice Group. And I've been practicing insurance law for about almost 30 years now. And I would say maybe about 10 years ago or so, started to take a deep dive into cyber and privacy related issues as they relate to insurance coverage, and have really made that a focus of my practice over the past decade or so.
And that's why you're here, because you and I have met years ago. You were actually sitting on a panel during, I don't know, Law Something Week here in the city. Week. Yes, that's right. And you and I met, and we've been chatting ever since. And so this delves right into what we both do on a daily basis. And that's all around cyber insurance, which is I say it's the last backstop to preventing a company from rolling all the way down the hill after a cyber event. Yeah. And so I've talked about this in previous videos, but why don't you give the folks an idea? What's the difference between professional liability and general liability and cyber liability insurance? Because there is a key distinction among any of those.
There sure is. And there may be a little bit of overlap in coverage depending on, the event at issue, but the really key differences and why I like your expression, stop you from rolling down the hill. The key benefit of the cyber coverage, which you do not find in the other policies, is the first party coverage, which is really a lifeline for companies, especially small and mid-sized companies that don't have the technical or the financial resources internally to deal with an event. And so those first party benefits, let's talk about a data breach situation. That would include the appointment of an attorney who's called a breach coach, to kind of manage the whole response to the incident. Find out if you did in fact have a breach. You may not have. You might just think you may suspect you had one, but you maybe did not have one. The breach coach becomes kind of not to use too many metaphors here, but the quarterback of this incident response team, which includes it can include, depending on the incident, forensic professionals, notification professionals, PR professionals. And the great thing about this is when a company or a law firm or somebody has a cyber incident, if they haven't really thought about it in advance, they may not know who to go to. Mm-hmm. And you don't want to start, shopping for these types of professionals when your house is on fire.
Yeah.
And it's hard to do. Now imagine if you have a ransomware incident and you're completely shut down, you can't even access your computer. And what are you going to do? Open up the yellow pages and start trying to find professionals to help you. And time is of the essence. And handling an incident, quickly and efficiently and legally, frankly, in compliance with relevant laws, really can save your reputation, can save you a lot of money, and save you time in getting this incident behind you. So that's one of the really key benefits of cyber insurance. The other great thing about this cyber SWAT team, as I call it, these are pre-vetted professionals most of the time. These are typically people who are, they compete to get on the insurance company panels. They're pre-vetted. They do this all the time. Their rates are pre-negotiated, which can be helpful as well. And they know the laws, they know the regulations, they know the regulators, they know how everything works, and they know each other. So they kind of work as a well-oiled machine. And just to be clear, I don't do this type of work myself. So saying this with all sincerity, the value that this provides is tremendous. It's just tremendous. And like I said, the best thing is to get the professionals involved, get a quick, efficient, legally compliant remedy, and response in place, and try to get this thing behind you with as little impact on yourself and on your business partners, your customers, as possible.
Yeah, and I mean, part of the problem is that a lot of businesses think this only happens to the large enterprise clients because that's all they see in the media. But what they don't realize are that at this point, hundreds of thousands, probably we might even be in seven figures by this time, of the small mid-sized businesses that get hit and have gotten hit. And this is damaging stuff. This is the type of incident that will put you out of business if you are not properly prepared. So I think people know my answer to this question, but I'm going to ask you this. Do you think cyber insurance is a necessity now for all businesses?
Yeah, because nobody is immune. It used to be people would say, following the big retail breaches of a few years ago, people would say, well, we don't have a lot of credit card information, or we don't have, the type of information like PHI, protected health information, that some bad guys would be interested in. But now, these are crimes. Typically, if you're talking about, a malicious event, it's a crime. It's often a crime of opportunity. And
Right.
they just look for, somebody, with an open port online. I had a client who had an incident like that very recently. They got an email from somebody who said, oh, I was kind of surfing, the web, and, I just happened to find, this vulnerability you had, and I just happened to download your files. This is a very small company, by the way. And it would be a shame if this stuff got out. And wouldn't it be nice if you gave me a reward for all my trouble? So there's those types of incidents. There are companies of all sizes, including very small, that just happen to have the right type of information from the perspective of a cyber bad guy. Whether it's intellectual property, or you're a business involved in real estate transactions or something like that. Even if you can be really, really small, you could be a very small law firm just doing some M&A work, or doing very high-end divorce work, for example, where they want that you specifically, because of what you do, are a very good topic for them. I mean, a target for them. So that just shows you right there. It just runs the gamut. And then you can't forget incidents that are not malicious in nature. We still see the incidents where, the employee doesn't look as the Outlook auto populates the to line in the email, and off go, all this confidential or protected information to the wrong email recipient.
Mhm.
We still see the lost laptops, that aren't encrypted, things of that nature. And another really key thing to keep in mind is that these policies are not just cyber policies, even though we call them that. They also apply, and I should take a step back. When I say they, it's really important to note there are no standard forms. All the policies are different. So you
Yeah.
really have to review the policy and make sure you know what you're getting. So big caveat there. But there are, these policies typically provide coverage for privacy related exposures. So that's, completely in the absence of any type of hacking or disclosure type of situation. We all know about, these privacy laws that are being proposed on almost like a weekly basis in various states in the United States. We have the European regulation, the GDPR, which applies to many US companies. We have perhaps a more robust regulatory scheme coming in Canada. And then here in the States, we have, California, Virginia just enacted a law that goes
Right.
into effect on the
2023,
January
I
1st,
think.
2023, exactly the same day that CPRA, the updated California law, goes into effect.
Right.
We have BIPA, which is the Biometric Information Privacy Act in Illinois. We have a BIPA clone proposed in New York. We have proposals in various states for dealing with these issues.
Mm-hmm.
So there's a lot of risk there for all types of entities. So, policies that can provide some good, robust exposure, coverage for all these privacy exposures is really, really key. And not to get too much into the wordings, because Sean, what a wordings geek I am about insurance policies. I spare you and the audience the super deep dive, but you just have to be careful when you're buying a policy. Not every company needs the most robust coverage. So that's one thing to keep in mind. But if you do need more robust coverage on the privacy side, some policies limit their regulatory coverage to incidents that arise from a security event or a data breach,
Mm-hmm.
as opposed to maybe you're just
A mistake. Yeah.
or wrongfully collecting information or not responding to a data subject request in compliance with a regulatory obligation. So if you're a company that is subject to these laws, you probably want to look for a policy that applies to any violation of a privacy law, as opposed to something that just goes to the security or to a data breach type of incident.
Well, and to your point about the privacy laws, which really starting to change here in the United States, it's already, GDPR is the European Union's version, but what New York and California and some of the other states, Virginia, is that it no longer matters where you are geographically. It matters if you hold data on their residence. And if you do, then you're subject to these privacy laws in these states. And I think that's where, especially on the small mid-size, that's where a lot of people are going to get caught. And it's going to be very painful, as you said, because the regulatory framework now, and you see it in New York, this is potentially a source of revenue for states starving for revenue.
Well, I think something else that companies need to think about, particularly small companies that may not meet the economic thresholds or the other type of thresholds to be themselves regulated by certain of these laws. Sometimes the laws will say, well, you have to have, revenue of X dollars a year, or deal with, you collect information from more than X number of residents or consumers, whatever they call it, in our state to trigger your any compliance obligation under the law. But what we're seeing constantly now, and I don't think it gets nearly enough focus, is you may be derivatively regulated by virtue of these contracts you're entering into. So we see this all the time where people are saying, hey, if you want to do business with us, you need to sign this contract where you are attesting to your business partner that you're compliant with
Right.
all of these types of laws. COPPA, FERPA, GDPR. They just throw everything in there, and you are warranting and you are giving indemnities. And also, by the way, really key point that we should talk about a little bit more as well. You're agreeing to add these business partners of yours as additional insureds under your insurance policy.
Yep.
And oftentimes you're saying, yeah, and you're primary. You get to go first in terms of recovery of any insurance proceeds. And now, how many companies are really looking at these obligations that they're taking on, and agreeing to indemnify, agreeing to provide insurance, and are they really factoring that into their risk management program? Understanding, are we insured enough? What if something happens and we are all of a sudden potentially liable to one of our business partners, 2, 3, 4 at a time? How would that play out? And so, nobody wants to be overinsured. That's for sure, because it's expensive.
Yeah.
And so insurance is getting more expensive now. But at the same time, if you do have uninsured exposures, you want to know about it. And if you don't want to buy more insurance for it, then and effectively go self-insured, you need to know about it. It just has to be part of your risk management plan, every year. And so I think that what I see and what colleagues of mine see in this area is, these contracts are presented, people are just kind of, yeah, let's get it done, let's get it done, let's get it done. What does this even mean? We don't even know what this means. Just sign it. We'll worry about it later. And when you look at situations where for companies, they could be looking at aggregated exposures, like, we see like the SolarWinds incident. Now, SolarWinds is a service provider to a lot of companies, but they about 300,000 of them apparently were at least thought to be impacted by their cyber incident. So conceivably, you could have 300,000 of your business partners coming to you and saying, "Hey, pay us for everything that we need to do." So that's kind of hopefully a worst case scenario, but it could happen.
To your SolarWinds point, there was the direct impact to SolarWinds clients, but SolarWinds clients were also impacted. So, I mean, it's not going to flow back to SolarWinds on there, but it will flow back to their clients to a certain extent. And there might be resulting action from that as well, especially if their clients don't have the coverage. So you are talking about this in terms of contractual language. And one of the things that I've seen recently is that insurance carriers, especially when it's coming to cyber, they're saying, we understand there's a difference between the value of the data to the company that holds it versus the value of the data to the company that owns it. And they don't want to pay the difference. And so they're saying you have to have contractual language that limits your liability should anything happen to that data. Are you seeing the same thing on your side?
Yeah, I was just seeing everything across the board, every iteration of this. But it really proves a point, Sean. That's a great example, because it really proves a point of how you have to look at this kind of holistically as as a company, as an enterprise. And a lot of people have been saying for years and years, data is the new oil, it's data is the new currency, but it really is true. And I think that's why we've had such an uptick in ransomware, because the bad guys have certainly figured out that the value of the data to the company that is holding it is what drives, I hate to say, but kind of the market value. for it, in terms of what you're willing to pay
Most
to
definitely.
get it back or to prevent its disclosure, or both, because now we're seeing more and more the combination of ransomware with a breach incident.
Yeah, I
So
was going to get to that, but I have definitely seen that from starting basically in middle to late 19, and then last year it just exploded.
exactly. So it's a scary situation, and so I'll go off on a little tangent on information governance here, which is a term that I still think is misunderstood, if it's to the extent it's understood at all. But it's really important if you're talking about ensuring information, if you're talking about protecting information, you have to know what you have. You have to know where it is. Where does it live in your enterprise? There should be some parameters around how long you're keeping it. And do you really need to keep everything forever, like a lot of US companies do?
Right.
Because we're litigious here, and they're like, well, storage costs are down. It'll cost me less money just to keep it than have to go through and figure out what to get rid of. So that's kind of a bad idea nowadays, because there's just too much risk to holding data. But do you even have to hold it online? Does it have to be online?
Right. And that was one of the things that since you went off on this tangent, I'm going to follow you on there, in that part of the problem also is that state regulations, federal regulations, industry regulations all treat data differently in terms of what you have to hold, how long you have to hold it, where it can and can't be held, so on and so forth. You throw in GDPR on there or some of the other regulations from some other countries, if you actually happen to do business in those countries. And now all of a sudden your grid matrix in terms of, okay, I have to meet this requirement, I have to meet this, and you're sort of left, companies are sort of left, and this can happen to any size company, saying, well, which one do I follow?
Yeah.
So from a legal perspective, what would be your default?
Yeah, it's really, really tough. And there's no hard and fast rule because the laws are conflicting. And so you really, I can't give you, a default position. You just really have to look at,
Which one would hurt the worst?
well, what is your company? What is your business?
Right.
Who is your primary regulator? What are you doing with the information? Do you have to do that with your information? And just try to figure these things out. This is the problem with, inconsistent laws. And, we just saw, on the US side, a federal privacy law proposed, I guess, just about a week ago, in the US House of Representatives, which has the support of the Chamber of Commerce, by the way, and some other organizations to try to it would preempt the state laws, I think, to a large degree, if not completely. We have to see what would happen.
Mm-hmm.
But it's so challenging for companies to deal with this patchwork of different laws that are just not the same, and in worst cases really kind of conflicting. But at the same time, there's some of the newer privacy laws have, this requirement that kind of, you can only keep the information for as long as you need it. You can only use it for the purpose for which you collected it and disclosed, this is why we're collecting, and you can only keep it for as long as necessary for you to do what you collected it to do, for.
Mm-hmm.
And so even those, I mean, like you said, there's all types of laws around the country in different states with retention periods, like you must keep tax information for this long, you must keep employee information for that long. That's hard. That's very complicated, and it's very hard to do. I've consulted companies on many occasions about data retention policies, and it's really, really hard. But now when you throw in these new consumer privacy laws on top of it, it becomes even more challenging, because then it's really not those specific types of special, for lack of a better term, information like around employees or taxes or something. And it's, so it's much broader. And we see under CCPA in particular how broad the definition of personal information is.
Right.
It's so much more than what we've seen over the years in data breach notification laws, which is, the name, in combination with, social, whatever it may be.
Right. I mean, there's a myriad of combinations. And just for the viewers' edification, CCPA is California's Consumer Privacy Act, which in November was voted to expand. And it is now CCPR or something.
CPRA.
Yeah, CPRA. Yep.
Consumer Rights Act. Yeah, which is going to amend it, some pretty significant ways. But the idea of, it's hard to do in retrospect. It's much easier. It's like if you're a brand new company starting today, get these good, solid data practices in place, know what you have, know where it is, decide in advance how long you're going to keep it. And there'd be exceptions to that, in case there's litigation or whatever, you have to put a lid hold on your documents. But try to do that, going forward. And even for existing companies, it's really maybe challenging to go backwards, but at least start looking at the stuff on a going forward basis and then deal with the going backwards, maybe as time goes on. It's really, really key to try to get a handle on this. You can't protect what you don't know you have if you don't know where it is. How do you respond to a data subject request who says, somebody says, I'm a California resident, give me all my data back, give me all my personal information as defined in CCPA. I'm exercising my right to have all my data deleted or transferred, or I just want to look at it. How do you even find it if you don't have good governance in place to know where that information is and to be able to respond to that request in the statutorily required time frame? Otherwise, you put yourself at risk for fines. So,
and I think to your point about data governance, it's also relates to the fact that if you leave the decision to the technology department, whether it's internal or external, they're going to do something that makes their lives simpler. Just because they have so much going on, they have so much on their plate that they're trying to take care of, even in small environments, that they're going to say, okay, you want this data? Okay, we're just going to store it with everything else, but we're going to create a new folder and it goes in there. Or we're going to build a new database and it'll go in there. But that's not, to your point, that's not governance. That's sort of, okay, let's just make it work.
That's kind of a management situation maybe, but, for, in a perfect world, and I know people love to hear this, start another committee. That's all we need is another committee and more meetings. But, in a perfect world, you would have, an information governance committee. And it would be a cross-section of relevant stakeholders throughout the company. So you of course would have your IT people there, but you would have legal, you'd have compliance, you'd have a chief privacy officer if you have one, probably a CFO, and because different people HR, if I didn't say that, different people recognize the value and the risks associated with different types of information, as well as the legal requirements that may attach to that information. So, to the extent, the IT guy says, well, I'm going to stick here. Does he know? Did legal tell him we need to be able to respond to a data subject request under X law within X number of days? Mm-hmm. When we get a request to delete, it has to be deleted everywhere it lives in our enterprise, So if we have that same person's information sitting here, and sitting here, and sitting here, we have to know that because we have to get rid of all of it, Right. And I'm using some broad strokes here. There's nuances to all these things, but that's kind of the issue. And then, if somebody who can appreciate the cost, the legal person who understands the legal requirements, but also the potential liabilities for not doing it right. And I think a lot of it, comes down to, no company has an unlimited budget. Nobody has unlimited resources in terms of people and dollars to spend. And so I think what companies have to often do is get into a situation of understanding what their requirements are, or their best practices. It shouldn't all be tied just with, compliance and checking boxes to comply with the law. It should be more thoughtful than that. But most companies will probably be in a situation where they have to start prioritizing. They probably won't be able to do everything at once. And so you're going to have to look and say, well, what are our biggest risks? What are our biggest priorities right now? What's driving our need to do this? Is it a law that we absolutely must follow? Is it because we want to, submit an RFP, or because our business partners are requiring us to do that? All those factors, will kind of go into it. And, when I work with companies, like over the past few years with CCPA, for example, there was a lot of talk is like, well, we're just going to figure out who our California residents are, and we're going to apply all this special treatment to California residents. And so our advice always is, well, yeah, that's fine. But just think about on a going forward basis, if it makes sense for you, fiscally and, operationally, to at least set in motion the ability to do this on a broader scale, because it's not going to stop with California.
Right.
And so, do you really want to be in the position every time a new law comes out, like, oh, panic, or if you're able to kind of get these processes in place across the board, and that way, when a new law comes out, that's different. The Virginia law is different from CCPA, CPRA, GDPR, although it takes little bits from all of them. At least you'll be probably 90% of the way there,
Right.
But it's hard, it's really hard. There's a lot of budgetary, financial concerns, and a lot of operational concerns. I'll never forget the first time I was working with a very, very technical guy, a CISO, and I showed him, we were sitting in the same room, and I showed him the NYDFS cyber regulation right after it came out. And this is a guy who has a lot of experience in financial institutions, so he was kind of used to, being regulated, in terms of cyber and privacy related issues. If you saw this guy's face as he was reading this, and he's like, we can't do this. We can't do this. If we encrypt this data here, it's going to shut this system down over here, and we're not going to be able to do this there. And so, we have to be really, really aware, especially, people like me or lawyers, who just say, well, this is what needs to be done. There are really serious operational impacts on companies. And it takes time and it takes money. And so that's why, as I say, I'm always a big advocate of not just checking the boxes for any one privacy or cyber law to the extent you can help it. Try to take a more high level approach.
Well, to your point about money and excuse me, and resources, but it also takes human resources, because none of this gets implemented by AI. I mean, it doesn't. It gets implemented by human beings who already have a very stacked plate on their other day-to-day duties. And now all of a sudden you're going to throw, well, if we don't do this, none of us may have a job because we may get fined or we may get fired and whatnot. And so when you're talking to your clients, how are you balancing out the risks? If you go into, let's say, a mid-size financial services firm in New York State who has to meet the DFS Part 500, has to file some federal regulatory filings as well, what are you talking to them about in terms of their structure and then we'll start to dovetail into how the insurance comes to work with them.
Yeah, well, DFS has been around now for a couple of years, and if you're regulated by DFS, you better be in compliance with DFS.
You've filed at least 4 times that you are in compliance.
Exactly.
So yeah.
So not a lot of take your time and just prioritize right now, because DFS you really should be in compliance with. But one area that I would really focus on if I were a DFS is making sure a couple of things, making sure you're doing what you said you were doing. Compliant today may not be compliant tomorrow, especially as you're bringing in new technologies, new ways of doing business. Let's say you have an acquisition, for example, so you're taking on a new company with their computer network and a whole new set of data. Who knows? But as your company evolves, as your technology evolves, as your business practices evolve, ensure your compliance. But I think one of the really biggest areas to focus on now is with your third-party service providers. That is just so massive, and we're just seeing it over and over again. All entities of all, every industry, all sizes impacted by cyber or privacy incidents affecting their business partner, their service provider, on whom they're dependent to some degree, depending on what the nature of the relationship or the service is. But that's very, very challenging. Under the DFS reg, you need to show a specified level of due diligence over these third-party vendors, and so you need to have some processes in place. And there's lots of companies that can help you do that. In terms of scoring them and giving them questionnaires on all types of things. That's really key. But the really interesting issue is, how far down does that go? What about your vendor's vendor and their vendor, and all of this kind of stuff. And it's super complicated, but that's an area that I would really focus on, because it's a rare company that doesn't use a service provider for a very key function now. Either they have access to your network, or they're hosting your information. Yeah.
I mean, email is the most common one, but I mean, your accounting system might be in the cloud.
HR.
Your HR might be in the cloud. Your employee information, your client information may be backed up to the cloud, a third-party cloud provider. I mean, that whole goes back to the HVAC vendor getting hacked, leading to 30 million or 150 million credit cards getting hacked. So, exactly. I mean, that's where it all originates, in terms of that fear of a third party being the weak link in your chain.
And now, proving what a geek I am, I'm a geek. I'm a wordings geek, probably more than anything. But just on even on the cyber, the compliance and best practices side, one of the really key things about the NYDFS regulation that I think is just such a good thing is that they don't just focus on the financial information that you get, the non-public information, they call it in the regulation, that you're holding. And the company's responsibility to protect that and secure it and all of that. But the regulation also focuses on your business information and your ability to stay in business, and recognizing the importance of these financial institutions, whether they're banks or insurance companies or insurance brokers or whatever they may be, to the economic viability or success of the state and of the country, frankly. And so I think it's important for everybody to realize it's not just protecting credit cards and social security numbers and whatever else is designated now as personal information under the various laws. Your ability, depending on what industry you're in, your ability to stay in business is also really important.
Well, so we're about 30 minutes in, and we've probably scared the hell out of people who aren't in this industry. Well, that's okay. I did a video this morning, and somebody referred to me as the boogeyman. So, that's just the nature of the business that we're in. So let's give some people some hope. If they're doing things right, let's assume that they do 75% of their IT right, because nobody does 100. It's just impossible to do it. So I'm always of the mindset, if you could be a C to a C plus and above student, we're good to a certain extent. When you implement cyber insurance, and again, the wording in these policies backward and forward, what are these companies looking for to make sure that the most common exposures for themselves are going to be covered? And then how do they learn what's not going to be covered?
Well, you said a key word there, like the exposure for them. The exposure for them. Not every company has the exact same exposures.
Right.
I think there are some common exposures that every company has. Everybody's susceptible. If you're online, you're susceptible to a phishing attack that can create a ransomware type of incident, or something like that, for example. But not every company has the exact same risk profile. That's the term I always use. It's not the exact same risk profile. And so it's really important for companies to understand what that risk profile is. And it is not just your IT risk. It's much more than just your IT risk. It's how you're collecting information, how you're storing it, how you're using it. Going back again, what are your your contractual obligations, that you've signed on to with your various business partners. All of these things, and one of the reasons I try not to use the word data, frankly, Sean, when I'm talking about this, is because it's not just electronic information. It's paper information, all types of information. And so that's something to keep in mind as well. So it's really key for companies to understand what their cyber and privacy risk profile is. And again, to do that, you need to get that same kind of group of people involved that we were talking about before. Of course, you need your IT, your information security people, your financial people, HR, legal, CPO, Chief Privacy Officer, if you have one. All those types of individuals to say, what type of information do we have? What are we doing with it? What are the drivers of potential exposures? Is it regulations? Is it contracts? Is it, whatever it may be? Really understand that. And then you go shopping for the insurance policy that best fits your need. And nobody's going to like this answer, but I'm going to give it to you anyway. You have to read the policy. You must read the policy. And Sean, you and your company are an example of brokers who understand what's in the policies.
Right.
A lot of brokers don't.
Yeah.
And to me, there's absolutely no substitute for reading the policy. And now reading an insurance policy is kind of an art. There are, they're subject to decades and decades and decades of precedent, legal precedent, court decisions that have come down and said, this is how we interpret these terms in a policy. It varies from state to state. One state can look at some policy wordings and say X, and another state looks at it and says Y. And we're seeing this play out in COVID to a degree. Some of the cases going on now there, but it happens across all lines of insurance coverage. So if a company has the resources, and again, I'm not pitching myself because I don't do this type of work, I represent insurance companies, hire a lawyer who really understands insurance law. It's great to talk to a lawyer who understands cyber, who understands privacy, but you need to talk to somebody who understands insurance as well. Yep. So they'll appreciate the meanings of some of the exclusions and the conditions and all these types of things. And as I say, and I think, Sean, you and I have talked about this. I used to advise companies on buying their insurance policies. And I had an example a few years ago of a company that was completely in the cloud. Absolutely. Everything was in the cloud, and they're in the financial services industry. So, their information is very sensitive. So, and regulated. So, they asked me to look at their cyber policy. They had more than one policy, which was kind of strange, but I'm looking at their policies, and one of them has 90 something pages. I'm reading this policy. I'm somewhere on page 70 something, and there's an endorsement to the policy that changed the definition of data breach, which to somebody like me is like, wow, this, I think every word really needs special attention, but this was like, wow, what's going on here? In the policy itself, in the beginning of the policy, it said, a data breach is, which you're covered for, is, something happens to the information in your computer system or that of a third party that's holding your information pursuant to a written contract. Okay. You look at this endorsement, the term third party is removed and the term independent contractor is put in its place. So it's saying information.
I'm going to stop people because this is kind of scary. I was going to mention this very conversation because it was the last one that we had in person, and you scared the crap out of me. So I ran back and started pulling the policies that I had just written, looking to make sure that that endorsement was not anywhere in any of the policies that I had just written. And I swear I was just going to bring that up in this conversation. So it's very funny that you're bringing this up.
It's a big deal because, the term independent contractor was not defined, but under various states' laws, it means an individual, a person. And so I doubt, Amazon would be considered, Amazon's cloud services would be considered individual,
Right.
And then there was another version of that endorsement I saw where they, instead of independent contractor, they said individual contractor, and that was defined as a natural person. So, like I said before, not every company needs the broadest coverage. So if you don't need to pay for that good third-party coverage because you just don't share your information with anybody, why pay for it? But in this situation, they did need it. They thought they had it, and they didn't. Right. So that was the problem. But then, we were able to get him, a policy that better fit his needs. And I don't say this as any type of criticism of the insurance company, because you have to read the policy, and for many insureds, it would probably be just fine. And they're like, and so that's kind of to your question, match up the policy coverage with your risk.
Well, I think that endorsement actually, when we were talking about it, we didn't sort of go into all the permutations that it could take, but I think that type of endorsement, and by the way, for those who don't know industry jargon in insurance, an endorsement is a change essentially to a policy that is added in after the fact to a certain extent.
Not after the fact.
Well, but it's added into the policy that you have to read because it's not in the front, it's usually in the back of the policy. So you got to make it through everything else to find it. But to a certain extent, everybody, if you have data backed up in the cloud, that endorsement, if the cloud provider is violated or breached, and you become responsible for the repercussions of that breach because of the contract you have with that cloud provider, well, then all of a sudden you may not be covered because it wasn't an independent contractor, it wasn't a human, it was a third party. Yeah. And I think in the technology arena, and I've seen this, I just had this happen, a managed service provider, which is an outsourced technology company that I work with, they renewed their policies last December. And they, because of circumstances, I wasn't as involved with the renewal as I normally am. And I finally got around to reading it about a month after they were into the new policy, and I realized that the carrier had changed the cyber provision and as part of the overall package, because they had a package and not a standalone cyber policy. And the changing of it took away most of the protections that this company needed. So now I'm scrambling to get a new policy in place to take over that does do the coverages, but it's because, again, because the cyber was originally not built in as a package, and then it was added as a package, and the carrier was saying, well, this makes it more convenient for everybody. They were under the impression that it was cyber, but it wasn't. It was a revised version of cyber. And I'm wondering, again, since you work for the insurance carriers, do you anticipate this becoming the new norm, that they're going to try to limit their liability and exposure to all this cyber, free for all going on?
I don't know. There was a push by the regulators in the UK a couple of years ago, I guess now, for companies there, the London insurance market, I guess, whatever, to either across all their policy lines, either affirmatively cover or affirmatively not cover certain cyber exposures. I'm seeing that more of that happening over here as well, where carriers are saying, we want cyber risks to come, to a cyber policy and not to be showing up inadvertently in different policy lines. So I do think there is an effort underway by many carriers to not kind of inadvertently cover cyber. But in my experience, the coverage for cyber risks under a cyber insurance policy in particular is, typically very broad.
Yes.
And there's so much misinformation out there about cyber coverage, where people are saying, oh, the policies aren't worth the paper they're written on, they never pay claims and all that. None of that is true. They do pay claims. The coverage is very broad. It's extremely expansive. Sean, I write articles all the time, and some of my most popular articles are when carriers come out with new coverages under cyber policies. I just write a short post and say, hey, now there's coverage for this, like, whether it was, back in the day, social engineering or what was it called? Like the reverse invoice kind of thing.
Yes.
Sorry, I'm not remembering the exact name, but
but it's phony invoices and whatnot. Yeah.
Bricking coverage, betterment coverage, all these things that they're coming out quite a bit, but over the past year, driven primarily by ransomware, there's been so many more ransomware incidents. They're costing a lot more money to remediate, and the ransom demands have also gone up. So it's like a triple whammy. And then to make it even worse, as we were saying before, now the ransomware incident is often coupled with a data breach or
Right.
a threat to expose the data if you don't pay. And I think sometimes they expose even if you do pay. I think there's some examples I've read about that. But in any event, I think the insurance market over the past year, to my understanding, has hardened. It's become more of a seller's market as opposed to a buyer's market. But and including the cyber market, I don't know if there's going to be really a cutback on coverage, but there might be a closer look at potential insureds and what they're doing in connection with their purchases of cyber insurance. The underwriters are probably going to take a closer look, especially at ransomware, past claims or past incidents, things of that nature. I think companies can expect a little bit harder look from underwriters in connection with getting the coverage. But again, I do think that carriers will probably, again, seek to ensure that, cyber privacy exposures are excluded where they're meant to be excluded, covered where they're meant to be covered, and kind of maybe channel those exposures into a cyber type of policy, as opposed to people trying to get coverage for these types of events under different types of policies, and getting perhaps just a coverage battle on their hands.
So, as a lot of people know, I give you prompt questions, and these are the ones that I had sent you originally. And I haven't looked at this once, but I think we've actually touched on quite a few of the questions. But I
I'm not
do want to
surprised,
ask you,
Sean.
say that again.
I'm not surprised.
Yeah, well, I mean, that's the way our conversations go. I mean, if people were a fly on the wall when we used to meet in the coffee shops, they'd realize, well, how the hell did you wind up on that topic? And it was because one of us said a word that just took us down
Just like
a
this.
different avenue. Yeah,
Yeah.
exactly. But I do want to ask you on the small and mid-sized market, because they're the most underserved because they don't have the financial resources to sort of hire that outside those outside resources to sort of make them all sorts of compliant. And they try to mix and match and do the best they can. So from that perspective, if they came to you and they said, okay, give me a game plan that I'm going to put in place that's going to make it virtually impossible if I have a cyber incident that I'm going to get a claim denied. Where am I going to focus my money and my efforts? And this is just small, mid-size. These aren't people that have the resources to go sort of hog wild on meeting these compliance. Where are we going to focus our efforts?
Well, it's kind of the same thing I said before. You need to make sure you have the coverage that meets your risk profile. And so these, it's hard in cyber and privacy because you never know what's going to happen tomorrow. Something
Right.
could be happening now that nobody is thinking about. But you want to at least make sure you identify what your current known risks are, and that your coverage matches up with those risks to the best you possibly can. Don't assume, well, we'll never have a ransomware attack because we're small or we're whatever, is a pretty obvious example. But another key, two other keys, Sean, maybe I'll make it three other keys to avoid jeopardizing your coverage. Let's assume you get the right coverage in place. And so your coverage is matching up with your risk, which is great. You want to make sure when you're applying for the coverage that any representations you give to the carrier in the application process are true. You want to be 100% forthcoming with the carrier. So if they give you a written questionnaire, you want to answer it accurately. If you've had incidents or there's something going on that might turn into an incident, tell them. It may affect your premium, it may not affect your premium, but I'm a huge believer in just being completely honest and upfront with the carrier and answering the questions. Like, don't say you encrypt your data at rest if you don't encrypt your data at rest. Don't say you have a chief information security officer if you don't. Things along those lines. Mm-hmm. And then when you get your policy, there are really important requirements in the policy that the insured, the policyholder has to operationalize. So you don't just buy the policy and put it on the shelf. You need to look at the policy and say, okay, how do we give notice of a claim? Whose knowledge is relevant to trigger our obligation to give notice of cyber policies is not necessarily a claim, it's just like an incident, mm-hmm. Or whatever terminology that particular carrier uses, but whose knowledge is relevant to that? Is it anybody who works in the company? So if the mailroom guy finds out that there was something, does that trigger your obligation, or is it limited to like a management committee, something like that? Know who it is, work with those people to make sure they understand what their obligations are, write it down, add the notification requirements that are applicable to you on your policy, add that to your incident response plan so that you don't forget, when your hair's on fire, God forbid if you're dealing with an incident, print it out so that if you have a ransomware incident, your incident response plan is not sitting on your computer and nobody can get to it. Also, we talked earlier about the panel professionals that most or many cyber carriers have and that are available for you to use. Oftentimes it's required that you use them.
Right.
And so, you can't say, well, we're having this incident right now. I don't know if I want to tell the carrier, I'm going to call my brother-in-law. He knows IT stuff. I'm going to have him come in and do a little forensic investigation, or I'm going to call my next door neighbor, the real estate lawyer. He's going to tell me whether I need to, do this or do that. You get yourself in real trouble that way. So know in advance what those requirements are, policy around who you have to use or you should use. Oftentimes, the cyber insurance companies provide free or discounted proactive loss control or risk management services that are, I don't know why people don't use them as much as they should. The uptake, in my experience, is very low.
Oh, yeah. Yeah. I mean, it's almost zero for my clients.
Yeah. And one of the services that many of the carriers offer is the ability to meet with one of these panel breach coaches for an hour or so. So you have a meeting with this firm, this lawyer, they could tell you some best practices, you get to know each other a little bit, they learn about your business. And God forbid, if you have the incident, you're not getting in touch with them for the first time. They already kind of know who you are, which has got to be of some value, when you're dealing with a cyber or a privacy event. So those are really, really key things to keep in mind. There's oftentimes, even if you don't have panel professional requirements, oftentimes there are other requirements in the policy you should be aware of, such as you can't spend any money without the insurance company's prior written consent. You can't settle a case without prior written consent. So, I've seen examples of companies that will have, a ransomware event, and it's not a huge ransom, and they're like, oh, we gotta deal with this right now. We'll pay the ransom. We'll give them $5,000, whatever it is they want, and then we'll report it to our insurance company. Depending on the policy wording, the insurance company may say, no, you had to tell us in advance,
Right.
and all that type of thing. So it's important to really know what your obligations are under the policy, operationalize them before you have an incident. And doing those types of things, Sean, between providing accurate information on the front end, knowing and operationalizing requirements on the back end are probably some of the best things you can do to avoid jeopardizing the coverage that you've purchased.
Yeah, and I think what you just did is you solidified my argument that this is a business problem. It is not a technology or an IT problem. This is truly a business problem because it's how the business side of the house responds to the incident that will determine how painful it will be for the company. It's not how the IT responds, because they pretty much have it down now. They know if this happens, I do this, I do this, I do this, to sort of stop the bleeding. But also, to your point, I think one of the other keys for those breach response teams that the carriers make available is that they're led by a lawyer. And that is very important should there be some sort of regulatory or civil action against the company because of the repercussions of the cyber incident. Having that lawyer guide you initially will definitely help protect you and solidify that you actually do things the right way.
Yeah, I think that's right. And there's also, although the law is getting more complicated in this area, there's a greater possibility that you'll get some type of attorney-client or work product protection over your, investigation and your remediation. It's sometimes when you look into these things, it's not always pretty what you find in terms of, well, how did this happen? And, maybe, there was a mistake and some patching wasn't done, or, there could be some, stuff you'd rather not have,
in the public eye.
The public eye or a plaintiff's attorney's eye concerning some things you did. So to the extent that you can apply some attorney-client privilege or work product protection over some of that. As I said, it's getting more complicated. That'll be another discussion another day. But I've written about it. If anybody wants to go look at, go on my firm bio and probably see all these articles listed, I think.
By the way, the firm bio is below in the video notes. So
is it? Okay.
it will be, yes.
Oh, good. And see some of the recent case law concerning that issue. But, it's certainly, to me, it's a really valuable exercise to try to get privilege to apply. And as you say, the attorney kind of knows the laws and can, even if you have an ugly fact pattern of, what happened with the incident, to kind of do everything right and in compliance with all the relevant laws and regs afterwards and dealing with your response is really key.
Well, what's interesting, back in 2019, we have a claims management team here that gets involved sort of working with the client and the carrier to make sure that the claims process is proceeding and up to date. And what we decided on the cyber side is that no more. Our claims management team will not be involved with the claims side of a cyber incident, simply because we tell them you immediately contact the breach response team that is part of your policy, because they're basically going to organize the entire process, and the claim actually rolls through that breach response team. And to your point about the attorney-client or work product privilege, that's the exact reason why I say I don't want to know what's going on, because the moment you tell me what's going on, you've just violated that, and you might have broken.
Well, maybe, but yeah,
but I don't want to. I don't want to be the one who says that the maybe. I'd much rather have it. I'd much rather have less people involved and keep it tight than having more people involved and then potentially creating a problem for our clients.
And it's the first thing that the people will ask for after an event. Show us your assessments and things of that nature. In fact, it's interesting, in the new Virginia privacy law, they require companies to do a data protection impact assessment. I can't remember if it's every year, every other year, something like that, but it's a requirement that they do it periodically, and they have to produce it if the state asks for it. But it's interesting because they put in the law, it's not subject to our Freedom of Information statute, and it doesn't constitute a waiver of any attorney-client privilege or work product protection if you give us the thing. So it just highlights the sensitivity of those types of investigations and the resulting documents.
Yep. Well, we were at an hour, and I knew it was going to go quick.
It was a lot of fun, Sean.
Yeah, this is just, if people can't realize, this is what happens when Judy and I sit down to chat, and it's why we like to do it over in person, because doing it this way is not nearly as much fun as sitting there and seeing the reactions and the guffaws and what have you as we go through all of our experiences. But I really want to thank you for doing this. I want to end it here because I want to be respectful of your time, and the viewers have probably watched this and they're like, damn it, can't we just go back to pen and paper?
We should think about that.
Yeah, I do very often at this point. But Judy, this was fantastic. Thank you very much. Sean.
Thank you. I love talking to you about these issues. Looking forward to doing it in person one of these days.
Yeah, and we will do a part 2 because there are so many more topics that we could talk about that relate to this. But until then, I hope you take care, and I hope everybody out there has enjoyed this. Again, you've been watching Did You Know That? ? If you like this episode, please hit the like button. And if you're new to the channel, please hit the subscribe with the bell, because as new episodes go up on Thursday mornings, you will get notified, and then you can watch at your convenience. And the like and the subscribe are somewhere down there. So make sure to hit it. Also, all the links to Judy Selby's profile and her writings and whatnot are in the video notes. Be sure to check it out. You're going to learn a lot. And as you can tell, she knows this industry inside and out. So, Judy, You take care of yourself, and everybody out there in the ether, you
Sean.
make sure you be well until the next time I see you. Take care, everybody.
Pleasure.